Cheque law is in existence since English days. But now with many amendments this law has become legal tool to exploit ordinary people for recovery of ordinary loans with inflated expenses and expenses. You take some facility and give a blank cheque. Because of various economic problems you are not able to repay and the person fills the cheque with inflated amount and files a case against you for recovery. Since the cheque is from your bank account and you have signed it, so the law mandates that you have given permission to fill it with any amount. Now you cannot prove that the amount is inflated or excessive. Because the cheque law provides presumption to documents and short criminal procedure. There are a flood of so-called legal experts who suggest many defense techniques without realizing that such defense is sure recipe for conviction in cheque case. Because you just go in any trial court and will find that more than 90 to 90% cases are decided against the accused. Many such experts suggest Supreme Court judgments. Most of such judgments are two-judge judgments which are obiter dicta and are given in particular case and not mandatory to be followed in any other cases. Even they do not read and fully understand such judgments and lift one or two sentences from here and there and suggest sure win. Written words have limitations and everything cannot be explained by words. So is the case with any law. So there are always technical and legal mistakes in any complaint. In any case, this gives immense possibilities to win any court case, particularly the case under cheque law. Every accused can come out of any cheque case easily. But attracted by immature advice from so-called legal experts who do not conduct cases in trial court but have only bookish knowledge, suggest easy solutions. The accused gets attracted and tries to get out of wall which looks near and gets further entangled in his own defense. To win, the accused has to learn to respond and not defend. By response, the opponent remains unaware about your strategy and hence cannot effectively counter it. This is the start of your winning journey. This is proved and tasted method from more than 500 years shown by Machiavelli. Again, your response should not be limited to any one or two methods. It should be well calculated and researched with many methods. One final method should always remain in reserve. Then what type of response the accused can take. There cannot be any fixed rule or formula since it will change in every case. However, we are giving here few examples. The complainant has to prove his evidence by direct evidence, but in most of the cases it is proved by leading questions. Most of the time the accused or advocate is absent when evidence is given and so no objection is taken. Thereafter, at various stages, accused gives admission to documents, so this most important illegality goes in record without any objection. Accused can take objection at any stage. However, it is most technical issue to objections should be properly and legally prepared and presented before the court. The accused has right to take cross by leading questions, but without exceptions the cross is taken by direct questions which proves the complaint, and even various faults in the complaint are cured by the accused by such direct questions in the cross-examination. Still, the accused can ask for further cross in trial court, high court and even Supreme Court. The main principle behind this right is that best evidence come before the court for proper and just decision. Another most important right of the accused is to point out legal mistakes in the complaint. The complainant is not allowed to produce evidence beyond the pleadings in the complaint. Most of the time it is overlooked by the accused and gets convicted by the evidence which was not pleaded in the complaint. The court give judgment based on evidence and how it is explained to the court. The best example is the case of Lakhanlal Saroj, who was in jail for 43 years as murder accused but was acquitted in June 2025 for want of evidence. The records were there before the court but nobody explained it to the court in legal manner, so he has to suffer. The landmark judgment of Supreme Court about leading questions is in Varkey Joseph case, which is being followed since more than last 25 years. In this case, the accused was acquitted of murder charge because the trial court had convicted him by evidence obtained by leading questions by prosecution. The prosecution has to prove the case by direct questions and not by leading questions. When a murder accused can be acquitted by wrong method of taking evidence, the cheque case is only civil liability. Most of the legal experts who make videos for cross-examination are all consist of direct questions and not leading questions. Even one direct question in cross can result in conviction. Only 1 in a million knows the methods of leading questions and how to use them. The concept of leading questions is in law books since inception. The Varkey Joseph judgment is being followed for more than last 30 years all over the country. Whether these so-called cross-examination experts have more expertise than the law or Supreme Court. Moreover, they cannot show a single judgment in any court which they have won by direction questions in cross. Take advantage of this most important right in the hands of accused in any case and can out of it legally. Offense's best defense. It creates confusion and mystery. Your last weapon of offense should always be in reserve. It can be used as master stroke. You have to avoid all types of vague offense which cannot be supported by law and evidence. You should proper planning and homework. That is what Machiavelli taught 500 years ago. And even now successful in all types of conflicts. Send us all your documents by email in English and our team will prepare step-by-step guidance if you are facing any check bounce case. If you are facing any check case, you can legally come out it very easily if you follow proper legal methods which are available to you as your legal rights. Thanks for visiting this video and please subscribe and share with your friends so that they can benefit in legal matters.